My name is Richard Creed. Yes, got the thumbs up, thanks you, Edith. And I'm a specialist foreign exchange and payment service solicitor with well over a decade's experience in this area. I own and manage Creed Solicitors, which is a boutique payments law firm. Our work includes drafting customer-facing terms and conditions, drafting outsourcing agreements, reviewing commercial contracts entered into with suppliers, and providing in-house legal services. I've drafted dozens of sets of terms and conditions for payment service providers, including for many household name companies. These terms have been reviewed many times by the FCA as part of their application to become a payment service provider. So I feel like I'm well placed to talk about the consumer understanding outcome of the consumer duty. Before I get into the detail of the webinar, I'll try and keep this relatively informal. So if you have any questions as we go along, please feel free to enter the question in the chat box, or if you want to ask a question, just unmute and feel free to ask it in person. If I don't pick the question up at the time, I'll try and answer them at the end or via email after the webinar. So today I'm going to talk to you about the consumer duty and specifically the consumer understanding outcome of the consumer duty. I'll provide you with some information on the consumer understanding outcome, talk about what some of the potential consequences are of getting the consumer understanding outcome wrong, with a particular focus on firms in the foreign exchange and payments industry. And I'll suggest some ways that you can get it right, again, with a bit of a focus on the payments industry. So there are 4 outcomes that the FCA expects firms to achieve as part of the consumer duty. The first is the products and services outcome. The second is the price and value outcome. And the third is the consumer understanding outcome. The fourth and final outcome is the consumer support outcome. So I'll talk to you in detail about the third outcome, which is the consumer understanding outcome. So the consumer understanding outcome applies to all firms involved in the production, approval, or distribution of retail customer communication. So for payment institutions and electronic money institutions, this would include its agents and its distributors. It applies to all communications throughout a firm's interactions with retail customers, including before, during, and after any sale of a product, and interactions that don't relate to a specific product. It also applies to all types of communications, including verbal, visual, or in writing, and from a retail customer, regardless of the channel used or intended to be used, including social media. So a firm is obliged to support retail customer understanding so that its communications meet the information needs of retail customers, are likely to be understood by retail customers, and equip retail customers to make decisions that are effective, timely, and properly informed. A firm must communicate information to retail customers in a way which is clear, fair, and not misleading. Among other things, a firm should use plain and intelligible language, and where the use of jargon or technical terms is unavoidable, explain their meaning as simply as possible. A firm has to make key information prominent and easy to identify, including by means of headings and layout. It also has to provide relevant information with an appropriate level of detail to avoid providing too much information, which might prevent retail customers from making effective decisions. So what are the risks of non-compliance? Sheldon Mills, who's the Executive Director of Consumers and Competitions at the FCA, said that as the duty raises the bars for firms we regulate, it will prevent some harm from happening, and it will make it easier for us to act quickly and assertively when we spot new problems. It is clear that with the consumer duty, the FCA have another tool which will make it easier for them to crack down on practices which they do not like. I thought it would be worth talking about some of the enforcement action which the FCA has taken under the Treating Customers Fairly regime to give you a flavour of what enforcement action under the consumer duty might look like, as I'm sure that some of you are wondering what the risks of not complying with the consumer duty are. So under the old, less onerous TCF regime, enforcement action included fines. So Barclays was fined over £26 million when some retail and small business customers who were offered consumer credit were treated poorly when they fell into arrears. Barclays failed to treat the customers fairly or act with due skill, care or diligence. Similarly, Lloyds, Bank of Scotland and the mortgage business were fined over £64 million as a result of not handling the payment difficulties of mortgage customers correctly from April 2011 to December 2015. Enforcement action includes loss of permission as well. Foreman Financial Services had its permission cancelled as the firm failed to comply with an award made by the Financial Ombudsman Service to a client of the firm concerning unsuitable advice by the firm. If there's any senior managers amongst you, they can be prohibited from holding a significant influence function in any firm. So a CEO was found to have failed to exercise due skill, care and diligence in overseeing the firm's risk management framework, especially regarding risks arising from the firm's business model, to ensure that they were effective and paid due regard to the fair treatment of underlying customers. That individual was fined over £86,000 personally, and he was prohibited from holding any significant influence function in relation to any regulated activities carried on by any authorised or exempt person or exempt professional firm. Your firm may also be subject to a skilled person report. So Stonebridge International Insurance Limited had a business strategy of maximising sales at the cost of the fair treatment of its customers. This included deficiencies in their sale process guides, resulting in customers being channeled towards broader and costlier cover. It included customer services personnel presenting barriers to cancellation when customers wanted to cancel their policies, and this approach was encouraged by the firm's training processes. They failed to take into account treating customers fairly when determining the incentive schemes for its own staff and the staff at outsourced service providers. There was also inadequate management information to enable management to assess the extent to which customers were being treated fairly. They were also found to have an inadequately resourced compliance department for effective monitoring. So Stonebridge was subject to a fine of over £8 million, this skilled person report, and a past business review and customer redress where necessary. The FCA can also issue a public censure if they deem it appropriate. So in terms of payments firms, you don't have good customer communications to protect your retail customers from APP fraud, and this leads to your customers becoming the victim of APP fraud, then in my view, you're more likely, as a result of the consumer duty, to have to refund your customer, which has been the subject of APP fraud in full. So for any of you that might not be aware, APP fraud is when fraudsters trick someone into sending a payment to a bank account controlled by the fraudster. And once the victim has sent the money, then it's often too late to do anything about it. For example, we're all aware of invoice scams, where fraudsters intercept emails, which include bank account details, going from one party to another, but the fraudster changes the bank account details so that they get paid instead of the genuine supplier. The consumer duty places upon firms the responsibility to avoid foreseeable harm. That's one of the 3 cost-cutting rules. If a firm identifies it has caused customers foreseeable harm, either through its action or its inaction, the firm must act in good faith by taking appropriate action to rectify that situation. So the FCA expects firms to do 2 things, and this is set out in their guidance. Firstly, you have to pay redress promptly when it is due. And secondly, you have to take existing decisions and guidance from the Financial Ombudsman Service into account and apply the same approach to cases which present similar facts. So authorised push payment fraud has now overtaken card fraud to become the largest type of fraud, both in the number of scams and the value of losses. In 2021, losses to APP scams totaled £583.2 million, and that was a 39% increase on the previous year. Now, many cases go unreported, so the real figures are likely to be much higher. Accordingly, in my view, APP fraud is foreseeable harm for your customers. Not all bad. The new PRIN 2A.2.13G states that avoiding causing foreseeable harm to retail customers doesn't mean that a firm has a responsibility to prevent all harm. For example, a product may have inherent risks which retail customers accept by selecting that product. Accordingly, if you adequately warn customers of the risk of APP fraud when they execute a payment, you will have a defense that you did everything you could and that the customer was made aware of this risk. Financial Ombudsman Service. So the Financial Ombudsman makes decisions based on what they view to be fair and reasonable in all the circumstances. As Sheldon Mills said, the consumer duty will lift the bar on what the FOS deems to be fair and reasonable. Therefore, if a consumer is the victim of APP fraud and complains to the FOS, and the FOS is of the view that you didn't put in adequate measures to prevent the foreseeable harm of APP fraud, then it wouldn't surprise me at all if the FOS deemed it fair and reasonable for that customer to be reimbursed in full. Aside from the consumer duty, the Quince Care duty applies to payment service providers. The Quince Care duty prevents a bank from executing a payment instruction where it is reasonable grounds to believe that the instruction is an attempt to misappropriate the account holder's funds. For example, the fact that the payment is for a significant sum of money and is outside the customer's usual course of business might constitute reasonable grounds. For those of you not aware, the Quince Care duty was established in the case of Barclays Bank versus Quince Care. In this case, a company called Quince Care had a loan facility with Barclays. A director of Quince Care drew down the loan and misappropriated funds. Barclays pursued Quince Care for the money when the loan was not repaid. Quince Care replied with a defence that Barclays was under a duty which it had breached to refrain from paying out the loan monies when evidence of fraud was available to the bank. In considering this defence, the judge held that such a duty did exist and applied to banks processing payment instructions when sufficient evidence of fraud was available to them. However, in the circumstances of the Quince Care case itself, the duty had not been engaged or breached, so the defence failed. But the Quince Care duty survived. In Phillips versus Barclays Bank, a claim had been brought against a bank by a customer who had been duped by a fraudster into paying £700,000 to so-called safe accounts in the UAE. It was held that the Quince Care duty does not depend on whether the bank is instructed by an agent of the bank's customer. It is capable of applying in any case. If the bank is on inquiry, the instruction is an attempt to misappropriate funds. As a result, it is possible that a duty of care could arise in the case of a customer instructing the bank to make a payment when that customer is a victim of APP fraud. Barclays Bank appealed this case and has been heard by the Supreme Court. We're still waiting a judgment on this case. For those of you on our mailing list, we'll send you an update when that judgment becomes available. If any of you want to go on our mailing list, just drop me an email after this webinar and I'll add you. You might be asking yourself, does the Quince Care duty apply to non-bank payment institutions? Unfortunately, for payment service providers, it does. This is because these entities will have an obligation to comply with the customer's mandate and, by implication, a duty to exercise reasonable care and skill in doing so. In Hamblin versus World First, it was assumed that the Quince Care duty applied to World First, which provided electronic money accounts. So the Quince Care duty means that PSPs have a duty not to execute a payment where there are reasonable grounds to believe that the instruction is an attempt to misappropriate the account holder's funds, including APP fraud. Accordingly, when communicating with customers, it is essential that you put in place proper warnings and safeguards about APP fraud. Further, the Payment Systems Regulator is proposing new measures to fight payment scams by proposing that all PSPs sending payments directly or indirectly over faster payments fully reimburse APP scam victims with only limited exceptions. This will apply to consumers, micro enterprises, and charities. So when working on your communications with clients, you should act as if you have to reimburse customers which are the subject of APP fraud. Firstly, this will minimize the risk that your customers are subject to APP fraud, which is obviously good. Secondly, if your customers are the subject of APP fraud, then it is less likely that you will have to reimburse them if you did everything that you could to warn customers about the risk. Thirdly, the legislation on having to reimburse victims of APP fraud is coming down the road. It's expected in 2024, so you might as well prepare for it now whilst you are improving your customer communications. So what can you do? If you haven't already done so, you should perform a gap analysis and put in place a plan to be ready by July 2023. This review should be comprehensive and should include online information such as your terms and conditions, your website, your frequently asked questions page, your leaflets and brochures, your website terms, your call scripts, and your post-sale communications. Excuse me. You need to ensure you get the basics right. Are your terms and conditions easy to understand? If you think that they are, how do you actually know this? Have you and your management team read them recently? Have you had someone else read them and give you feedback who is not in the industry and not professional? You work with people buying houses in Spain. Have you tested this with your typical client? You can test it by asking clients a few questions after they have agreed to them. You could also have a few customers, a selection of them, review the terms in detail and provide you with feedback or answers to some queries that you pose them. And in return, give them a small fee or money off their next transfer or foreign exchange deal. The chances are if they were drafted 20 years ago with bits added over time, then they will probably need to be redrafted. The tone of the terms is important. You want a friendly tone that customers can easily understand. Were your terms sort of originally hashed together from bits of other people's terms on the internet kicking around? If so, then they will likely need to be redrafted. Do they clearly set out the complaints procedure open to customers and when the FOS is available to clients and when it's not? If not, then this will need to be inserted. Do they use technical jargon? By jargon, I know some terms are very common in our industry, such as forward contracts, but that they're not generally understood terms publicly. So if you use those terms, can you replace them with common usage terms or plain English? Or if you can't, can you explain what a forward contract is or another technical term is in your terms clearly? Do you have a separate set of terms and conditions for consumers and businesses? If you work for both consumers and businesses? If not, you should put these in place. Consumers will not want to read terms that apply to businesses and includes wording on businesses having authorized users or opt-outs that PSPs are availing of in relation to businesses. Terms are tricky to get right. They have to include all the detail prescribed in the Payment Services Regulations 2017. For foreign exchange of payments firms, they usually have to include details on spots and forwards, and when you safeguard and when you don't, when margin might be called and when it won't, and they also have to be accessible to clients. Quite a tricky balance to strike. The idea would be to make the terms, if you make them available on your website, interactive. So your website terms could be displayed as a table of contents, where it's easy to click on a relevant area and then there's a drop down with the sort of detail underneath it. An easy win would be to get the term read out by a voiceover person to help any customers with difficulties reading. Very good way of showing the FCA if they ever ask what you're doing to improve your customer communications. You could also give customers the ability to click through the terms to explainer videos on different concepts, such as forward contracts, safeguarding, margin calls, and indeed how to complain. You can have a help center on your website which explains the services you offer. Some ideas would be explainer videos on your complaints procedure, explainer videos on what a forward contract is and what spot contract is, explainer videos on when money is safeguarded by the PSP, when money is not safeguarded, maybe a video on when you might make a margin call, and also a video on what is APP fraud, or common types of APP fraud, how to spot APP fraud, or key steps to take to ensure that the payee details on an invoice are correct. Links to the help center could be sent with the customer onboarding pack. Links to appropriate videos could be made when a customer wants to enter into a forward contract or pay a new payee. Now, these could be paid for graphic videos if you have the time and the money for that, or they could simply be videos filmed on your laptop or your iPhone from an appropriate person within your organization. Obviously, you want to check it before it goes live on the website. So what you can do is have appropriate warnings at the appropriate times during the customer journey. We've all seen these probably on our own personal banking providers' websites and apps. When you add a new payee details, we need to have warnings about APP fraud. Do you trust this person? How do you know this person? And all this helps the customer think about what they are doing before they do it, and also gives you a bit of a defense if things do go wrong. So in summary, you don't want to get this wrong. I think I've made clear that enforcement action is no joke. Having to reimburse a customer for APP fraud, even if you only have to do it once, could cost you hundreds of thousands of pounds. The legislation requiring you to reimburse victims of APP fraud is coming down the road, and we won't be able to avoid it. So make sure you're thinking about APP fraud when you're building your customer communications. Check your terms and conditions. Make sure they're fantastic. Anything less won't do. Create video content that explains the tricky parts of your business. You should link your video to your terms and conditions and vice versa. And look at all your communications and the whole customer journey. In addition, if you have agents or distributors, make sure you're talking to them now about what they are doing as well, because obviously they're relying on your regulatory license. So if they do something wrong, then the FCA will talk to you about it, and not necessarily the agent, the distributor. You are responsible for it. So as a thank you for attending the webinar, we'd be happy to give a excuse me. There we go. We'd be happy to give a complimentary 30-minute chat with any registrants that have queries or want to discuss their approach to complying with the communications outcome of the consumer duty. My email address is up there on the screen. Okay, I think that's it. If anyone has any questions, feel free to email me, or I'll send around a link to have a 30-minute chat if anyone wants it. Really appreciate you all joining here today, and have a lovely rest of your day.